I'm Professor Wes Porter. We're talking about the Federal Rules of Evidence, and specifically Federal Rule of Evidence 201 that has to do with judicial notice. Judicial notice is akin to a stipulation, except the other side's not going to agree. It's something that's a little awkward to try to put through witnesses because it's something that we can take notice of as the court. We can say, yeah, that's readily identifiable. That's something that's easy to figure out. We can take judicial notice. The rule has a lot of other parts of it. The court can do it on its own. One party can move. If one party moves, the other party obviously has an opportunity to be heard to say, don't take judicial notice of this. And it often relates to the jury instruction at the end of trial. If the court takes judicial notice of something in a civil case, it's conclusively proved. And in a criminal case, the court may or may not accept the proof. Most important part about judicial notice is 201B. Let's talk about that. So 201B talks about the kinds of information that are ripe for judicial notice. Judicial notice goes wrong when one party tries to take a whole part of their case, take an element of their claim, take an element of the crime, and try to say, court, just take judicial notice of it. Can you take judicial notice of an entire element that I would have to prove? Can you take judicial notice of the other side's negligence in this case? It's not the type of thing that is ripe for judicial notice. It's something that's not subject to reasonable dispute. So those things are why you're going to trial, presumably. So think of it as it's something that can be easily determined. When does the sun rise? What was the temperature on a given day? What is something in geography that two streets intersect? That's the type of thing that a court can take judicial notice of. It's often related to the territorial jurisdiction of the court. So if the court's sitting in San Francisco, I used to teach in San Francisco, everyone there knows, and a court there would know, that Market Street, the main thread that heads through downtown, does not intersect with Embarcadero. They actually don't meet. You take judicial notice of that. If asked by one side or both sides agree, it's kind of like a stipulation, maybe, but the parties aren't stipulating. And just think about how awkward it would be to have a witness that would come in and somehow testify that two streets don't intersect, if that somehow was relevant in the trial. So think of judicial notice as the stuff that can be not subject to dispute, easily subject to dispute, that it could be, it's part of the thing that the court knows, court can do it on its own, or we can supply the court with information so they can take judicial notice.